hosted by the Illinois State Bar Association Young Lawyers Division. And we are very lucky to have three esteemed judges with us today. So I will be co-moderating. My name is Rachel Simon. I'm an associate at Miller, Shackman, Levine, and Feldman. And my co-moderator, Kaylee Barrett, is an associate at Momkus in Lisle, Illinois. So as I said, we have three esteemed judges. We're very lucky to have with us today. So I could take up the whole hour by just listing their accomplishments. So rather than do that, I'll just introduce them very briefly. So first we have Justice David Overstreet on the Illinois Supreme Court. He was elected to that position in 2020. And before that, he was an appellate justice, and before that, a circuit court judge. So he's covered all of the levels of the Illinois judicial system. And then we have Judge Michael Scudder on the United States Court of Appeals for the Seventh Circuit. He was nominated in 2018 and unanimously confirmed by the Senate. And then we have Judge Celia Gamrath from the Circuit Court of Cook County. She's in the Chancery Division. She was appointed by the Illinois Supreme Court in 2010, and then later elected and then retained by the voters. So thank you all so much for coming. And Judge Scudder, I apologize for all of the technical issues. Thank you so much for being here. So I think I'm just gonna start off with a question for everyone, and we'll just kind of answer this first question, at least in the order of presentation, with Justice Overstreet, Judge Scudder, and then Judge Gamrath. And then from there, we'll direct questions to individual panelists and give the other panelists an opportunity to chime in if they have anything to add. So this first one is just kind of a broad question. So as you all know, we're talking about oral arguments today. And I've always thought about something I heard one judge say to me, which was that, you can never win a case on oral argument, but you can lose one. And that made me think, what do you think about that? And what do you view as the real value of oral argument versus just something that is submitted on the brief? Justice Overstreet, we'll start with you.
Thank you, Rachel. And it's a real honor to be with you today. And I appreciate the invitation from the Young Lawyers Division of the ISBA. Oral arguments are very important in my mind. And so I disagree with the premise of the saying, and I've heard it as well, but it's your last chance to convince the court of the merits of your position. And it's a chance to, yes, the court is prepared, read the briefs, but we need the oral arguments in most cases, I think, many cases, to clarify the positions, to distinguish the cases. Just I find that you can make a difference in oral argument. Certainly, we look at the briefs and the law, and ultimately the law and the facts will dictate where we go. But certainly, the oral arguments, you can increase your odds of prevailing, and with a poor performance, if certainly if the law is not on your side, can also lessen your chances of ultimate success.
Judge Scudder?
Yeah, Rachel, thank you for the invitation to be here today. Happy to participate. I agree entirely with what Justice Overstreet stated. Oral argument absolutely matters, and it matters to my mind for three reasons. It presents an opportunity to learn, to confirm, and to test. And what I mean by that is there are many cases that we go into where we just can't figure something out from the record. It may be a big point. Oftentimes it's a smaller point, but nonetheless a material point. Oral argument also provides an opportunity to confirm some aspect of your understanding of the case or an aspect of the law that's important, and confirmation is valuable to decision making. And then the third aspect of it that's really important is it gives you an opportunity to test boundaries. In appellate law, oftentimes we're very focused on where the legal bounds of a particular principle lie, and being able to push and pull on the boundaries of that principle are important, and oral argument serves as a vehicle for doing so. So it's indispensable to our decision making.
Great. Judge Gamera?
Thanks, and thanks for inviting me today. Of course, I'm going to echo what they said. Oral argument is really a chance for you to have a conversation with us and to convince us why you should win. It's also a chance to address any doubts that the court may have in ruling in your client's favor. And particularly if you are the appellee, I would say this is your chance to act as a surreply to that reply brief that the appellant has put forward. So this gives you a chance to crystallize your thoughts, your key points, and to show the judges that you are credible, you're prepared, you're precise, you're knowledgeable, and all of those should translate into a win for your client.
Absolutely. Thank you all so much. Something that stuck out to me that, you know, this is a question really for our appellate judges here. So when you're on a panel, you know, I think everybody was talking about how it's a conversation with the advocate, but I know I have listened to Supreme Court, United States Supreme Court arguments before and thought, oh, the justices are really talking to each other. And is that, you know, is that another role that you see oral argument playing, you know, when you have a panel to kind of facilitate that conversation? Or do you see that as more of kind of a, you know, a behind the bench thing, and it's really more about conversing with the advocate? Anybody?
Rachel, I'll go ahead and take it first. From my perspective, I mean, I think primarily when we are asking questions, I mean, we're asking questions to the attorneys. However,
it seems like it'd be great to do some kind of a.
However, let me say this. I find it extremely helpful, and I'm listening, whether the questions from one of my colleagues is directed toward me or not. Mm-hmm. I'm listening and I'm learning from them as well, from either perhaps their perspective or an angle they're coming at it that I had not considered. So it's very educational for the colleagues on the panel to listen carefully to the questions being asked by the justice. Although I know when I ask questions, it's directed to the attorneys.
Got it.
Yeah, the questions that are asked through the kind of intermediary, if you will, of an attorney, I think are oftentimes a way of highlighting either in terms of emphasizing or de-emphasizing to one of your colleagues a particular aspect of the case. And so as you hear a question or you hear part of an exchange that one of your colleagues is having, just as Justice Overstreet is emphasizing, you're paying close attention to that. And, you know, you're processing that in terms of the way, you know, you're analyzing the case overall. So I think it's two directions. It's primarily at the lawyer, but there's definitely, you know, a horizontal dimension to it just across the bench. It's valuable.
Great. So one thing that I actually meant to kind of ask in the beginning was, you know, I kind of went through each of your backgrounds as, you know, judges, but I wanted to ask about your experience with oral argument when you were practicing. I know we've got a wide range of, you know, experiences from private practice to government work, and, you know, how much you actually did oral arguments in your practice, and how, you know, if there's maybe a couple of things that you've kind of learned on the bench being on that side, seeing oral arguments, if there's anything that you that really surprised you or was something that you wish you had known when you were practicing. So let's start with Judge Gamera.
Sure. So in private practice, I did quite a bit of appellate argument and started my career actually as an appellate law clerk. So that was a nice transition. So I would practice and prepare quite a bit as a practitioner, not just really honing in on usually my 3 key strongest points, but also practicing answers to the really tough questions about my weakest points. Because if I couldn't have a good answer or be confident in my weakest point, I knew that the judges would not want to listen to the rest of what I had to say. I would lose them at that point. So in terms of giving advice, I would say prepare, know your case better than anyone when you step up to that podium. Be prepared to answer questions and practice them. Practice them out loud if you need to. Record yourself. Just get it into a rhythm so that it truly is a conversation between you and the judges so that you could explain those kind of dangling questions or uncertainties that they might have. In terms of my courtroom now, I sit in a trial court, so it's much less formal than it would be for Judge Scudder or Justice Overstreet. So there's a lot of back and forth between me and the attorneys because I ask questions. It's really important for me to get it right. So I'm not afraid to ask questions, to ask lawyers to explain it to me, to make sure that I fully understand what this case is about and that I'm going to rule the right way. So in terms of the benefit of now conducting oral arguments, my practice really gave me a great foundation to work with. And I really value it. I think that the lawyers value it. And the more you do it, the more your confidence is going to grow. So I would just also suggest don't turn it down. Every time you file a brief, ask for it. The only time to ever turn it down is when your brief is just so superior that you fear that your oral argument is going to weaken your position. But otherwise, take advantage of the opportunity.
Great. Just Overstreet, do you have anything you'd like to say on that?
Sure. I had the privilege of arguing probably about 5 times in front of the 5th District Appellate Court in Mountain Vernon over the years when I practiced law, and it was always a privilege to do that. It wasn't something I did all the time, obviously, but one thing I learned from those experiences, answer the question. This is the opportunity to educate and persuade the panel you're in front of. And so, the most memorable case I can remember from arguing in the appellate court was when I had opposing counsel who decided not to answer a question, and when he or she was redirected back to the justice's question, made a comment about, well, that's really not important, or that's not relevant, and that's the wrong answer. So it's a great opportunity to engage in this discussion with the judge, and what we as a court, we're wanting to learn. We're wanting to, I think Justice Scudder talked about, I like that, to learn, confirm, and test. That's what's going on, and as an advocate, welcome the opportunity to do that, and be prepared first and foremost, as Judge Gamreth said, but answer the questions asked.
Mm-hmm. Thank you. All right. Judge Scudder?
Yeah, I agree entirely with everything that was said, and rather than repeat, let me just try to emphasize one aspect of what Judge Gamreth is saying and what Justice Overstreet just talked about with practicing, preparing, and putting yourself in a position of being confident. The reason that matters is because you're increasing the likelihood of being able to have a conversation with the court. The more prepared you are, the more fluent with the law and the facts, the more comfortable you're naturally going to be having a discussion about it, because you've spent a lot of time with it. You've had discussions with yourself about it. You've had moot courts, et cetera. And the more that you're able to have just a fluent conversation about the case, you're naturally going to be more flexible and not beholden to a particular script that you may have prepared or that you may have running through your mind. And flexibility is important in oral arguments because you can pivot around with a lot of facility by answering a particular question and then moving right back just quite naturally to a point that you need to make. And so getting yourself in a position through preparation and practice of being confident is going to yield a lot of really tangible benefits when you're on your feet in front of a group of judges. And I did quite a bit of appellate work in private practice, never argued in front of the Supreme Court, but a lot of courts of appeals, and the closest I got was a non-bank argument. So I did quite a bit of it.
Thank you. So, one question that all of your responses raised to me is, as much as an advocate prepares, and they feel like they've covered all their bases, they've mooted, they've, practiced questions, there can still be a question that you just did not prepare for, or sometimes maybe a question that you just don't have an answer to. So what, Judge Scudder, if you want to start here, what advice would you have, for an advocate who gets asked a question that they really don't know the answer to? Like, how should they respond to that? How should they handle that?
Two things for me: be candid and don't guess. So if you don't know, you don't know. It's not, you may think you should know, and you may be kicking yourself for it that way. But the worst thing to do is to somehow try to win it or fake it, because if you're being asked the question, it must be because it's on a particular judge's mind. And there's almost always an opportunity to follow up on the question. So that's my advice. Just honesty is the best policy there. And the last thing you want to do is guess and be wrong, because by doing that, you're going to spend a lot of credibility.
Sure. Justice Overstreet, do you have anything that you would add to that?
No, I agree 100%. Well
okay.
said.
All right. What about you, Judge Gamera?
Same.
Okay, great. And so I think, Judge Gamera talked about, taking every opportunity to, do an oral argument, except in, very rare cases. So I wanted to ask, Judge Scudder, when do you think an oral advocate should waive oral argument? I know sometimes in the Seventh Circuit cases will be assigned, to not have an argument. So I know sometimes it's not necessarily up to the advocates, but are there instances where you think that oral argument is just not helpful?
Rarely.
Okay.
I think there are cases where your position is either foreclosed by precedent or so closely foreclosed that you could make a quite reasonable determination that the expenditure of resources on oral argument doesn't make a lot of sense that way. And I could see it there. I would absolutely not waive oral argument in a situation where you may think, you've been dealt the weaker hand and you have a bit of a long shot, because the process of oral argument matters, and it should absolutely matter to your client that she or he felt like they had their day in court, even though it may have been a bit of a long shot. And especially if you're talking about people that are incarcerated and their liberties deprived and they're serving a long time in jail, I think it's very unsettling to think we waived oral argument. We just didn't give it a shot. I'd be hesitant to do that.
That makes a lot of sense. Justice Overstreet, do you have any thoughts?
Yeah, as a general rule, I think you should never waive oral argument. It'll make your make your final pitch to the court, and certainly your client would seems like would expect that as well. And so, yeah, I see very few situations where I believe oral argument should be waived.
Okay. So kind of shifting here, I have to ask about how oral argument has been going in your courts with the pandemic. I know that, there's a lot of courts were doing virtual, some were just doing audio, some are now back in person. Can you, I'll go around, we'll start with Judge Gamrath. If you could just kind of tell us like what it's been like in your court and, where things stand now, as well as, how it went, how it's been going. Do you feel like advocates can be as effective in that setting? And just, yeah, your thoughts on that.
Yeah, so I do. So we've been very fortunate with technology. So since March of 2020, we really, at least in Chancery, didn't miss much of a beat. Most of our cases have lawyers with good technology. And because I'm not doing jury trials in general Chancery, there's a lot of argument on summary judgment motions, motions to dismiss, and so forth. I found it very helpful when the lawyers know technology and know how to screen share. I found that they can even be more effective because this is giving them the chance to put up PowerPoints or slides during argument that they would never do in my courtroom. That said, I conduct oral argument in my courtroom, and sometimes people are live when they want to come in. For the most part, they're still appreciating Zoom, and so I'm allowing that to happen, and it's been really successful. So I do think that remote appearances are here to stay. So I would encourage lawyers to get up to speed with technology, know how to screen share, use these resources, throw up a PowerPoint, be even more effective using this technology than you were before. But in my courtroom, I do conduct oral arguments every day, either in person or remote.
Great. Judge Scudder, could you tell us how it works on the Seventh Circuit?
Sure, we're back in person now. There are some litigants that are opting to do argument remotely. That's available right now. There's no absolute firm requirement that you be there in person. I think throughout the pandemic thus far, we've done well with technology. Putting a bookmark on our docket and trying to wait out the pandemic, that's not an option. And the technology that way has been, a real godsend. It's allowed us to move forward, and as Judge Gamble said, we really haven't missed a beat that way. I'll just speak for myself though. I would be quick to say that there is a real loss of dynamic through Zoom screens. That there's just no substitute for in-person argument and just being able to read body language and the natural kind of give and take that is able to happen when you're in person. And I'll say one other thing, and that is it. And I don't want to. I'm going to be careful not to over generalize, but I think my view is that the quality of argument declined by Zoom, and the reason that I would say that is because we can tell that there are a lot of lawyers who would come in to oral argument and right next to their Zoom screen they'd have an iPad or a second laptop or something, and they would often use it as a bit of a teleprompter. And so we had a lot of argument, a lot of opening and closing portions of argument kind of being read to us. And I often found that we would ask a particular question about something, and you could almost instantaneously see a lawyer's arm move to where they were scrolling through that laptop to find the answer. The likelihood of that happening in the courtroom, in my experience, is less. Lawyers oftentimes, they know they're going to come up to the rostrum, be standing right there in the well of the courtroom. And they put themselves in a position through that preparation we were talking about to have a lot of the really material points at the tip of their tongue. And so I don't want anybody to hear me overstating that point, but if you said, is the quality absolutely equal? I would say no, in my judgment, no.
Justice Overstreet, what about in your court?
Well, I went on the Supreme Court a year ago, and our first term was set for January. We went remote. There was a COVID issue at that time, but every other term, so March, May, September, and then we just concluded in November, we've been live. And it's my understanding the Illinois Supreme Court was live last November as well, after going Zoom for 1 or 2 terms right after COVID hit. I know in the 5th District Appellate Court, where I served up till December of last year, we went remote Zoom oral arguments, and I believe the 5th District is still conducting Zoom oral arguments. I will say that I prefer live. I think the dynamics are better. The very interesting observation from Justice Scudder about the quality of oral arguments. I don't know that I've noticed that so much because, again, we've been live since at least March of this year. We do allow the Supreme Court allows an attorney who cannot appear can appear by Zoom. So we've had oral arguments where you had 1 attorney live and 1 Zoom. And we've had a few oral arguments where neither attorney could appear live, and so they were by Zoom. But as a general rule, everyone is live now from the Supreme Court. And I think the dynamics and the give and take is better live. But I will say this: I'm extremely impressed with the way the circuit courts, the appellate courts as well in the state of Illinois have adjusted since the pandemic hit. And again, things have not stopped. There have been great strides made in some fashion. Remote uses of court time is here to stay. In some hearings, it's better than others. But from my position on the Supreme Court, I certainly would prefer to have the advocates there live.
Sure. So I'm going to pass over the questioning to Kaylee. I should have said this at the beginning, but if people in the audience have questions for the panel, feel free to put them in the chat, and we will, go through those and try to get as many as possible toward the end. So feel free to start sending those as you think of them. All right, Kaylee.
Thank you so much, Rachel. I want to circle back to something I found interesting that was brought up by Judge Scudder in regards to being flexible within your oral argument and the importance of having that flexibility. How can advocates balance being flexible and not being too rigid in terms of sticking to the brief, while also not veering too far off of the materials in the brief and what the case is really about? How can advocates strike that adequate balance? And Judge Scudder, I'll start with you.
Sure. I think it's through the practice and the preparation. So if you were to hear, you have an outline in your mind or in your notebook right in front of you, and you have certain points when you approach the court that you want to make, your kind of must make points. But the moment that you start getting questions, which can happen quite early, at least in our court as well, you're going to be kind of pulled away from that. But if you practice by having questions put to you that they may seem like detours or what have you, and you can get comfortable with addressing that question exactly as Justice Overstreet said. You got to have to answer the question, but then getting efficient with pivoting back that way, and just keep getting peppered in your practice and preparation with getting pulled off the path you want to be on. You're going to get more adept at moving right back to the affirmative points, that you need to make. I think, let me say this, that the the Supreme Court of the United States, Illinois Supreme Court, same way, really, really blessed with talented advocates that appear in front of them. And because you're interested in cases or what have you, one thing that I'd encourage you all to do is listen to some arguments. And you're going to hear some extraordinarily talented advocates, and they're going to get, knocked off their affirmative outline constantly, but you're going to see some real talent on display in different ways that they're pivoting back to making affirmative points. So you can kind of learn through that observation.
Thank you. Justice Overstreet, do you have anything to add on that point?
Well, just to echo that, the ability to pivot back to the key points you want to hit is, it's a great skill. And Judge Scudder, he hit it on the head. I mean, the outstanding advocates we have in front of us at the Illinois Supreme Court, it's a real privilege to be able to preside over those cases and to watch the skill of these advocates as they do answer our questions, and but they still have the skills to pivot back to the points they want to make, and it all comes back to preparation.
And I think on that note of preparation is something that Judge Gamreth brought up in one of the earlier questions, especially in terms of not only preparing, but practicing. And I think Judge Gamreth mentioned, the more you do it, the better you become. And since we are, the Young Lawyers Division, I wanted to direct a question to Judge Gamreth about how a young attorney can kind of get that practice, and what opportunities that you would suggest they take advantage of to really hone their skills.
Ask for it. So don't be afraid to ask your partner, can I argue this motion? Can I argue in the appellate court? You've already probably done 90% of the brief writing. You know that record inside and out. Have the confidence to ask. They may tell you no, but go back and ask again on the next argument. Eventually, they'll say yes, unless it's a bet the company type case. Ask for it. Secondly, in Chancery, I have a lot of arguments. So when I see younger lawyers really involved in a case, and I feel confident that they're going to do a good job, I have been known to turn to the partners and say, we're setting this for argument. How about if Ms. So-and-so argues it? And sometimes the senior partner looks at me and says, well, okay, I'll ask my client about that. And it's usually very affable. And I turn to the other side and say, fair game, let your associates do this. Give them this chance and opportunity. And it really does work well. So those are my tips in terms of getting yourself into the room to make those decisions and to get some practice.
Thank you. I think that's great advice. It looks like we have a question from one of the attendees, and I'll just open this up to the panel. The question is, any advice when there is a cold bench? Is that advice different for appellee or appellant?
Well, I haven't seen any cold benches on the Illinois Supreme Court yet, but I know, having served on the appellate court, there are times when perhaps the justices don't have as many questions, and I know that is a challenge for the advocates, because you want questions as an advocate to know where the justices are coming from and what points you need to put a lot of emphasis on and to address. But I guess the key is if you've got your outline in your head or the points you want to hit, you keep going. And I don't know what you do if you have a cold bench, because that's out of your hands.
Judge Scudder?
Oh.
No, Judge Gamreth.
I was just going to say, going back to my days when I practiced and faced a cold bench, you do not need to use all your time. Justice Scudder said earlier, time goes quick. Sometimes the questions start right away. And that's why it's really important for you to get to your main points right away. So always have that 2-minute speech prepared as to what you really need to tell the court. And if they don't have questions, maybe that's all you need to tell them are your winning points. And then sit down. Don't waste your time by reading the brief, reading things that they're not interested in hearing about.
Yeah, I don't have anything to add. I agree entirely. We had an oral argument not too long ago where cold bench, the case just wasn't all that difficult. Important to be sure, but not all that difficult. And the appellee, after about a minute of making the affirmative points that he needed to make, started to go on and almost kind of open the case up and try to explain it. And I had a colleague say, you're not compelled to use all your time. You don't want to be in that position. Just use your common sense. And when you've made your points and you sense the bench is cold and you put on the table what you need to put on, just be confident and ask if there's any further questions. And if there's not, you're done, sit down.
I think confidence has been a theme throughout this panel, so it's a great tip for us all young advocates. Another item that was brought up in terms of the virtual oral arguments that were had in the past year or so is the reliance on maybe a laptop or another screen as kind of a crutch for the argument itself. What, in your opinion, what materials should an advocate be bringing up to the podium, if any, and what is too much that would then become ineffective in terms of their oral argument? And Justice Overstreet, if you want to kick it off.
Well, again, an advocate should be prepared and flexible. Some of the points we've talked about. I think less is more. I mean, as little as you can. You can't take a binder up. You're not going to be thumbing through looking at things. So, I don't think you need a whole lot. You know the case. You've got pertinent notes, perhaps reminders, cases, whatever points or facts you want to bring out. Have those with you, but you definitely don't want to be encumbered by a binder, or as was mentioned, scrolling through your screen trying to find something, and that'll waste time and be ineffective.
Does anyone else have anything to add?
I agree entirely with that. I have two kind of bookend points to make on that. I would not also go to a podium empty-handed. One of the most skilled advocates in the United States is Paul Clement, and Paul Clement often does that in the U.S. Supreme Court arguments, but there are not too many, if any, Paul Clements, and I would not recommend that, because that's putting your own memory and recall and what have you to a test that you really don't need to. On the other end of the spectrum, we have seen lawyers come to court without their briefs, and oftentimes there'll be a question pop up about, well, where did you make that argument, or did you advance this argument in your summary judgment motion below or something, and you don't want to be in a position of saying, I think so, but I don't have my briefs with me. That's an entirely self-inflicted mistake.
Judge Gamreth, do you have anything to add?
No, other than the fatal mistake that I saw once was somebody coming up literally with binders, and there's not a lot of room at that appellate podium. And so inevitably, one fell off. It was a big distraction. This was when I was clerking. I never forgot it. So less is more. Have what you need. If you need to have that security, keep it at council table, but don't bring it to the podium.
That makes sense. So we've talked a lot, we've given a lot of advice, not we, you, the panelists have given a lot of advice in terms of presentation and preparation for oral argument. But what would be, you know, the one key tip for an attorney who is about to do their first oral argument? What would be your number one tip to provide for them in advance so that they feel confident and prepared to step up to the bench?
Well, you know, keep in mind, you as the advocate know the case better than the judges you're going to appear in front of. You know, in most cases, it's your case. You know the facts. You should know the applicable law to your case. So that should give you confidence when you appear in front of the court. And when you have the confidence, you're going to project that to the court. Again, all goes back to preparation. Remember, since we're all in this together, it's not that the court is against the lawyers, or we're all trying to learn from each other. Obviously, the court has to make the decision, and you have some give and take, but it's an indispensable part of our justice system. You've got the privilege to be part of that for your client, and again, that should give you the confidence to know that you're going to engage in this discussion, this argument, and give it your best shot for your client, and help the court, again, educate and inform them about your position. So again, I stress, welcome the opportunity to participate in this oral argument.
Judge Gamera or Judge Scudder?
I'll leave the best for last, so let me go first. But let me just say, know your goal. So know what you want the court to do and explain why they should do it. And sound like you care. I think Justice Scudder touched on this earlier. Be confident, show eye contact, sound like you care. This is really important. And make it such that the judge could trust you, that you are helping them come to the correct results. And that's my best advice.
Let me emphasize one point that I think is very hard to overstate, that Judge Gamera focused on early on in her comments, and that is, I think when you all are approaching oral argument, what you're very naturally going to do without really any effort at all, because you know your case so well, is you're going to focus on the strong cards in your hand and the affirmative reasons for why you think you should win. Everyone's going to do that. That's the way you've presented points in your brief. Those are the affirmative points that you want to make. And I actually think what you should put the most focus on in preparing for oral argument is, how am I going to answer the questions I'm inevitably going to get about the weaker cards in my hand? Because don't convince or allow yourself to become persuaded that your case is perfect. No case is perfect. And if cases are getting to the Illinois Supreme Court or our court, I can almost assure you that a lawyer on each side of the case would love, if they could, to swap out a weak card for a strong card. And what you have to anticipate is that the questions you're going to get are not focused on your 4 strong cards. They're focused on your 1 weak card. And so in your preparation, think of all the possible ways that you could get asked a question about that weak card. And that's where you're really going to shine. When that question comes up and you're ready for it, and you've got a really crisp, organized, and articulate response ready.
Thank you. So it looks like we have a few more questions from the audience. And one of them touches on something Judge Scudder brought up earlier in terms of not bringing the brief to the oral argument. Someone asked, how do you feel about advocates needing to pause or to take a moment to find a case citation in their notes or the brief or a record site that the court brings up specifically? Is that something that is looked positively on or negatively?
I can respond. Yeah, I think positively, so long as the pause doesn't become unreasonably long and convey that the attorney's unprepared. That way, if it looks like you're on kind of a search from scratch, that's going to be a problem. But if it's just, oh yeah, I know exactly where that's at, just give me a second, and it turns out to be, 5 or 10 seconds, I think that's totally fine. In fact, it may show a level of kind of diligence and candor that adds to your credibility. It's much better than just guessing or winging it. You don't want to do that.
Right. And then our other question, which I'll direct to Justice Overstreet and Judge Gamreth, is do non-verbal cues play a role at oral argument? Can advocates' demeanor affect the results of their arguments?
We notice, and it certainly, I can tell when an attorney is, I don't see eye rolling or anything like that at the Illinois Supreme Court, but when an attorney is flustered, perhaps they sense that things are not going their way, sometimes that's noticeable. It's not held against them. It's just something I mentally note. And yes, obviously you're making your argument. You always want to be respectful to the court, to opposing counsel, and do the things we should do as lawyers and behave the way we should behave in court. And so to the extent that doesn't happen, it's noticed. But again, being confident as opposed to feeling like, you're getting swamped. Sometimes signals are given off and we notice those things.
Thank you. Judge Gamreth, do you have anything to add?
Just in the trial court, it is a little different. And I do on occasion see eye rolling. I do see arms going up and eyebrows raised. It's never professional. It's never persuasive. And so again, you are going to get to make your point. And I tell everybody that in my courtroom, you do not need to step over one another. I will give you the opportunity to respond. So just be cautious of that. Eye contact, nonverbal cues do affect your demeanor and the court's judged credibility on you overall. So just be patient, be civil, and be professional.
It's interesting. I attended a panel the other week, and it was brought up that some judges had observed the lack of civility has increased almost based on remote proceedings, and that attorneys seem more hostile maybe towards each other than they would be in the courtroom, where you can work things out in the hallway before stepping up to the bench. I'm not sure if you had observed that as well, Judge Gamreth, in your courtroom.
There is a mix, but I will say the success that we have had in the judicial system is in large part because of the cooperation of lawyers. So we as judges very much value the lawyers and how they've been able to adapt and cooperate and not run in on nonsense, realizing that there's bigger issues and bigger things in this world than a minuteness of some discovery dispute that's not the company's sort of thing. So I've been really pleased with the level of civility and cordialness and cooperation that I've seen, at least in my division.
That's great. That's great to hear. So I think one question that it would be very beneficial for us to hear your wisdom on is the fact that a lot of times it is very rare for attorneys to get feedback on their oral arguments, and they may give an oral argument but not know how it went or think that it went horribly, and not really have a chance to hear any constructive criticism on how they can improve. So what would you say, what would you tell attorneys to do to try to improve on their oral arguments for the next one, with that lack of feedback that we don't always get?
I think it makes sense to, as painful as this may be, to watch yourself if it's a video proceeding or listen to the audio. But then, find a colleague, another attorney to watch and give his or her critique of how well you did and on steps you can take to do better next time.
Yeah, what I would add is, as you're getting started in your career, I think one mistake you can make is to be a little too hard on yourself. That way, if you prepare and practice, I can almost assure you that preparation is going to manifest itself in your argument. One of the things that I often hear young lawyers say is, I think I was too anxious and too nervous, and people have different levels of comfort, in their own skin, standing in the well of a courtroom, making an argument. That's all quite understandable. And I think be careful with just being too tough on yourself. I think if you're anxious and nervous, you're reacting the right way. If you're not, I'd really be worried about it that way. And so just have a long view of your career and stay at it and try to do better the second time than you did the first, et cetera, et cetera. And if you have that drive to improve and you don't lessen your preparation, you're going to get better the more you do it.
Yeah, and same practice, record yourself, bring a trusted, objective colleague who could give you true constructive criticism moving forward. As Justice Scudder said, listen to other oral arguments, observe them, try to emulate them, and with practice will come confidence and improvement.
Thank you. I think that is all really excellent advice for all to take home today.
Kayla, I'm gonna go ahead and step in here real quick and I want to kind of wrap things up. I want to thank you and Rachel for moderating today and helping us through this process of just getting some insight as to how to be effective oral advocates. Again, I just want to thank our justices and judges for lending their time, their lunch hour, no less, to talk to us and help us out and just mentor young lawyers. So we can't thank you enough. We have our next food court event coming up on January 12th. So look out for that. We'll be sending out information related to the topics and the judges and all that stuff here shortly. And again, just a big thank you for everyone who's attended and worked on this and for the judges for their time. Thank you guys.
Yeah, thank you all so much. It's been a really wonderful conversation and I really appreciate you all being here.
Thank you.
Thanks.
All right, everyone have a great rest of your day. Thank you all so much. All right, bye.
Bye.
I learned a lot too, so thank you so much.
Oh, good.
Thank you,
Wonderful. Yeah.